Welcome to the appendix, where we read the primary sources of the past so the present can be better understood. Today's primary source: Hamilton's opinion on the constitutionality of the bank, February 23, 1791, as taken from The Works of Alexander Hamilton, edited by J.C. Hamilton, Volume 4, page 104. December 14, 1790, Hamilton presented to Congress his plan for the establishment of a national bank. A bill embodying most of the features of Hamilton's plan passed Congress February 8, 1791. Washington, doubtful of the constitutionality of the measure, requested Hamilton, Jefferson, and Randolph to submit written opinions on this question. Randolph submitted two opinions, one adverse, one ambiguous. Hamilton's opinion is one of the ablest of his papers. It contained the substance of the argument subsequently adopted by Marshall in his decision in the case of McCulloch versus Maryland. Washington accepted Hamilton's argument and signed the bill February 25th. In entering upon the agreement, it ought to be premised that the objections of the Secretary of State and the Attorney General are founded on a great denial of the authority of the United States to erect corporations. The latter, indeed, expressly admits that if there be anything in the bill which is not warranted by the Constitution, it is the clause of incorporation. Now it appears to the Secretary of the Treasury that this general principle is inherent in the very definition of government, and essential to every step of the progress to be made by that of the United States, namely, that every power vested in a government is in its nature sovereign, and includes, by force of the terms, a right to employ all the means requisite and fairly applicable to the attainment of the ends of such power, and which are not precluded by restriction and exceptions specified in the Constitution, or not immoral, or not contrary to the essential ends of political society. If it would be necessary to bring proof to a proposition so clear as that which affirms that the power of the federal government as its objects were sovereign, there is a clause of the Constitution which would be decisive. It is that which declares that the Constitution and the laws of the United States made in pursuance of it shall be the supreme law of the land. The power which can create a supreme law of the land in any case is doubtless sovereign as to such case. This general and indisputable principle puts at once an end to the abstract question whether the United States have power to erect a corporation, that is to say, to give a legal or artificial capacity to one or more persons distinct from the natural, for it is unquestionably incident to sovereign power to erect corporations, and consequently to that of the United States, in relation to the objects entrusted to the management of the government. The difference is this: where the authority of the government is general, it can create corporations in all cases. Where it is confined to certain branches of legislation, it can create corporations only in those cases. It is not denied that there are implied as well as express powers, and that the former are as effectively delegated as the latter. And for the sake of accuracy, it shall be mentioned that there is another class of powers, which may be properly denominated resulting powers. It will not be doubted that if the United States should make a conquest of any of the territories of its neighbors, they would possess sovereign jurisdiction over the conquered territory. This would be rather a result from the whole mass of powers of the government and from the nature of political society than a consequence of either of the powers specially enumerated. It is conceded that implied powers are to be considered as delegated equally with express ones, then it follows that as a power of erecting a corporation may as well be implied as any other thing, it may well as be employed as an instrument or means of carrying into execution any of the specified powers as any other instrument or means whatever. The only question must be, in this as in every other case, whether the means to be employed, or in this instance the corporation to be erected, has a natural relation to any of the acknowledged objects or lawful ends of the government. Thus, a corporation may not be erected by Congress for superintending the police of the city of Philadelphia, because they are not authorized to regulate the police of that city. But one may be erected in relation to the collection of taxes or to the trade for foreign countries or to the trade between the states or with Indian tribes, because it is the province of the federal government to regulate those objects, and because it is incident to a power sovereign or legislative power to regulate a thing, to employ all the means which relate to its regulation to the best and greatest advantage. Through this mode of reasoning, respecting the right of employing all the means requisite to the execution of the specified powers of the government, it is objected that none but necessary and proper means are to be employed, and the Secretary of State maintains that no means are to be considered as necessary but those without which the grant of the power would be nugatory. It is essential to the being of the national government that so erroneous a conception of the meaning of the word necessary should be exploited. It is certain that neither the grammatical nor popular sense of the term requires that construction. According to both, necessary often means no more than needful, requisite, incidental, useful, or conductive to, and it is the true one in which it is to be understood as used in the Constitution. The whole turn of the clause containing it indicates that it was the intent of the Convention by that clause to give a liberal latitude to the exercise of the specified powers. The expressions have particular comprehensiveness. They are, quote, to make all laws necessary and proper for carrying into execution the foregoing powers and all other powers vested by the Constitution in the government of the United States or in any department or officer thereof. To understand the word as the Secretary of State does would be to depart from its obvious and popular sense and to give it a restrictive operation, an idea never before entertained. It would be to give it the same force as if the word absolutely or indispensably had been prefixed to it. The degree in which a measure is necessary can never be a test of the legal right to adopt it. That must be a matter of opinion, and can only be a test of expediency. The relation between the measure and the ends, between the nature of the mean employed towards the execution of a power and the object of that power, must be the criterion of constitutionality, not the more or less of necessity or utility. This restrictive interpretation of the word necessary is also contrary to this sound maxim of construction, namely, that the powers contained in a constitution of government, especially those which concern the general administration of the affairs of a country, its finances, trade, defense, etc., ought to be construed liberally in advancement of the public good. The means by which national exigencies are to be provided for, national inconveniencies obviated, national prosperity promoted, are of such infinite variety, extent, and complexity that there must of necessity be great latitude of discretion in the selection and application of those means. Hence, consequently, the necessity and propriety of exercising the authorities entrusted to a government on privilege of liberal construction. But the doctrine which is contended for is not chargeable with the consequences impugned to it. It does not affirm that the national government is sovereign in all respects, but that it is sovereign to a certain extent, that is, to the extent of the objects of its specified powers. It leaves, therefore, a criterion of what is constitutional and of what is not so. This criterion is the ends to which the measure relates as a mean. If the end be clearly comprehended within any of the specified powers, and if the measure have an obvious relation to that end, and is not forbidden by particular provision of the Constitution, it may safely be deemed to come within the compass of the national authority. There is also this further criterion, which may materially assist the decision. Does the proposed measure abridge a previous existing right of any state or of any individual? If it does not, there is a strong presumption in favor of its constitutionality, and slighter relations to any declared object of the Constitution may be permitted to turn the scale. It is presumed to have been satisfactorily shown in the course of the preceding observation: 1. That the power of the government as to the object entrusted to its management is its nature sovereign. 2. That the right of erecting corporations is one inherent in and inseparable from the idea of sovereign power. 3. That the position that the government of the United States can exercise no power but as is delegated to it by the Constitution does not militate against this principle. That the word necessary in the general clause can have no restrictive operation derogating from the force of this principle. Indeed, that the degree in which a measure is or is not necessary cannot be a test of constitutional right, but of expediency only. 5. That the power to erect corporations is not to be considered as an independent or substantive power, but as an incidental and auxiliary one, and was therefore more properly left to the implication than expressly granted. 6. That the principle in question does not extend the power of the government beyond the prescribed limits, because it only affirms a power to incorporate for purposes within the sphere of the specified powers. And lastly, that the right to exercise such a power in certain cases is unequivocally granted in the most positive and comprehensive terms. A hope is entertained that it has by this time been made to appear to the satisfaction of the President that a bank has a natural relation to the power of collecting taxes, to that of regulating trade, to that of providing for the common defense, and that as the bill under consideration contemplates the government in the light of a joint proprietor of the stock of the bank, it brings the case within provision of the clause of the Constitution which immediately respects property of the United States. Under a conviction that such a relation subsists, the Secretary of the Treasury, with all deference, conceives that it will result as a necessary consequence from the position that all the specified powers of the government are sovereign as to the proper objects, that the incorporation of a bank is a constitutional measure, and that the objections taken to the bill in this respect are ill-founded. Thank you for joining us for our primary source today on the appendix. We will see you in the stacks.